Good afternoon, everyone. On behalf of Data Privacy Group and Nadia Global, we are welcoming you at today's webinar devoted to the UAE data protection laws and regulations. Let me start with the introduction of organizers of the today event. This is Nadia Global and Data Privacy Group. So Nadia Global is a leading training and recruitment company in the UAE. It started 40 years ago in the field of recruitment and training in the whole region, and they trained over 350,000 of professionals. Nadia Global is trusted by its clients, and we partnering with Nadia Global on delivering our course on the UAE data protection law. A little bit about our company. I'm representing Data Privacy Group, which is international group of companies consisting of data privacy offices and data privacy schools around the globe. We are specializing in data protection. We have a lot of experience with international standards and laws like the GDPR or ISO 27701. And we bring this course adapted to the UAE requirements, but with the use of the best practices and knowledge that we acquired in the European Union, which is much more regulated area, and other regions. So today we'll speak about the UAE data privacy law. This is the federal law, but I must say that before we start speaking about that, we need to tell a bit about ourselves, and I'll start with myself. My name is Siarhei. I'm a data privacy professional, certified information privacy manager, technologist, and professional. I also hold MBA degree from Germany. I started my work with the GDPR in 2015 when I entered IT risk and security field at Allianz SE in Munich. And I've been delivering the trainings on data privacy, mostly about the GDPR, since 2017. So we trained over 3,000 professionals on the GDPR and other regulations. And my co-speaker today is Manish Mishra. Manish, would you like to tell about yourself?
Thanks, Shreya. Good afternoon, everyone, and a very warm welcome. I'm Manish Mishra. I'm the Data Protection Officer for Mashrak Bank. I'm CIPP and CISM and ISO 27701 lead implementer certified. I have been into data privacy domain since 2017 mid, where I have exhaustively worked on regulations like GDPR, then India Privacy Regulation, Qatar Central Bank Regulation, Bahrain PDPL, Dubai DIFC, Hong Kong PDPO, etc., and a couple of other frameworks like Central Bank of Kuwait, Cybersecurity Framework, US DFS Framework, etc. Currently, in my role at Mashrak, I am their Global Data Protection Officer. I'm ensuring the data protection related compliance for the 12 geographies in which Mashrak operates. Prior to joining Mashrak, I have been with Ernst & Young in financial service advisory area, where I have advised clients like banks in Qatar, banks, French-based bank, UK-based bank, and a couple of global banks in their privacy compliance journey. Also entities like International Monetary Fund, FinTech ecosystem, and startup ecosystem back in India. Prior to EY, I have spent good around 7.5 to 8 years of my time with HSBC and RBS. And I'm happy and excited to be part of this session. Thank you.
Thank you, Manish. It's great to have you here, especially since you have both background in information security and information privacy, and maybe you'll be able to explain people what is the difference between those fields. But before we go to this difference, I must say that our presentation will focus on 5 main points. We'll start with introduction to the UAE data privacy law, the requirements of the law, and then we would focus on the sectors that the law applies to. We'll touch upon the benefits of law compliance, and we would also discuss what companies have to do to become compliant and what is the first step for becoming compliant. Maybe we can start with overview of the requirements of data protection law, but actually the flow chart I'm using at my UAE data privacy professional course that we deliver together with Nadia. It shows all all major stages of becoming compliant with any data privacy law. But I must say that we make compliant not the company, the whole company, but rather the processes with personal data. So every time we start with data privacy program in the company, first thing we do, we usually make data inventory and make the inventory of the purposes for processing personal data, and we check what kind of data and what information system is located. Then we analyze what kind of regulations and laws apply to the data. And the ground question here would be, is the information personal? Then we would be asking ourselves about what access do we have to the information, what material, whether this process falls into the scope of the law, material and territorial. We would identify what kind of obligations we have, and those obligations depend on our role, whether we are data processor or data controller, or maybe we are third party in certain processing. And then, depending on our role and the scope of obligations, we have this long way to comply, to make our process compliant with any law. So we start with finding legal basis. It's basically what every company in the UAE will start with. First, we will identify what kind of processes would need to be supported by consents of data subjects, of individuals, and what purposes, what processing we could ground on other lawful basis, like contract or the requirement of law. We would make the processing transparent with privacy notice. We would limit our processing with the purpose that we declared when we collected the information. Then we would minimize the data involved and keep this data accurate, delete the data right after the purpose was fulfilled, and assess the risk of the processing, and make sure that we'll make sure that the processing does not harm individuals. We would also have to answer their requests. They have certain rights in accordance with the federal law, and in case of breach, and this is a question of time, when we get the breach, not whether we get the breach, we would have to notify supervisory authorities and individuals. Then there are a number of obligations connected with information security, with international data transfer. There are certain limits on the countries, on the jurisdictions we could transfer the data to, and the requirement to keep the evidence of all steps that we made to make sure that we are able to prove that everything that was mentioned before was actually carried out and is not left only in paper, but also it has certain practical evidences inside of your company. Yeah, and usually when we start with talking with managers and owners of the companies, they sometimes mix two quite different fields, which are data privacy. They sometimes think that it's the same as information security. So they imagine that we would be doing some technical things in the field, on the ground, like antiviruses or data loss prevention systems, etc. And that's great to have you, Manish, here, because you are actually a professional in both of the fields. So how would you describe the difference between them?
Thanks. So it's a very kind of a mix and match situation when we talk about information privacy and information security, which we also called as cyber security. So information security and or cyber security as such is I could say a bigger umbrella where everything that you do end to end is covered under that umbrella. Now, data privacy, if I look at it, not just information, but from a data standpoint, barring the legal and the process related obligation, the technical aspect of controls, like if you have to say, do a data classification activity, if you have to honor data subject rights, or if you have to provide enhanced protection to our data with controls like encryption, masking, pseudonymization, a concept like privacy by design, right? So all these will form under the bucket of cybersecurity or information security. Whereas other controls of information security like VAPT, your endpoint protection, your network firewall, your data leakage prevention enhancement, antivirus solution, all will come under the bigger umbrella of cybersecurity. So the exact figure that is replicated here on the screen, so the confidentiality of personal data is basically achieved with combination of both. Now, but if you talk about the other obligation of privacy, which is privacy policy, which talks about consent mechanism, which talks about contractual framework, which also talk about your cross-border data movement, etc., are the other pillars of privacy which kind of sit outside the gamut of cybersecurity. So this is where your teams like legal, compliance, HR, procurement, vendor management, etc., will come into play. And on the right hand side of the box, it's all your information security, your technology team, your IT teams, and the suite of infrastructure services will come into play. I hope that answers or gives some clarity to an extent.
Yeah, totally. So what are the benefits of becoming compliant? So with your experience of making large corporations compliant with different international and national laws on data privacy, what are the best achievements? What are the best, benefits they got from the process? Because it's a lengthy and I would say even costly process.
So very rightly said, any privacy program is at least a 2 to 3 year journey, and it is a costly affair. Now, whenever you go to business, there is always a question, or there is always a ask somewhere that what is my ROI? What are the tangible and intangible benefit that I would get while I am, implementing this? Getting compliant with the regulatory requirement is one of the ask of this, right? It's one of the major benefit of it, that regulator will come and they will see that you are compliant and you are doing the right thing in terms of data protection, and you are compliant. But the larger benefit of it is basically is customer related. So the first and foremost benefit of any organization to enable privacy compliance is basically the check mark or the tick in the box approach, where you can say that yes, there is a regulation and I'm compliant to it. These are the requirements and this is what I'm doing with it. Now, the other important part is that the changes that you do as a part of your privacy program, they tend to increase your cybersecurity posture or an information security posture. So that is one of the key advantage, because it has multiple impacts on it, right? The second major benefit of this is that you are able to, because of the enhancement in the cybersecurity posture that you do, you are able to prevent or protect certain data breaches or impact of any data breach if that happens. Okay. Now, when you protect the breach related impact, then you are able to protect both employee and customer data, and any impact which is a negative impact that might cause to them because of a breach, which is any impact on their financial freedom, their well-being, their independence, and their psychological impact, all can be reduced or covered to a greater extent. Now, not only this, right, you can also do is your brand value get improved in the market. As we are moving toward digitization, people are also becoming very tech savvy. People read the documents, people read the guidance, people read the regulation, people are very connected. So, people in UAE will very well understand that people in UAE get data subject rights, or you European residents sitting in UAE, working in UAE, will understand the importance of our data subject rights, right? So if your organization is able to fulfill those, or there is a mechanism in which your organization is able to meet those obligations, then there is a definite increase in the brand value of your organization. There is a respect from your brand value, because you are doing something that your competitor can't do, and there is a faith that comes in a customer as well as your employees that your data is in the right hand, or your data is kind of protected. it somewhere, also aligns with your principles, ethics pillars, or the vision and mission statement of your organization. So privacy programs give your alignment to this. We are also talking about benefits of privacy program in your environmental sustainability and governance agenda. So if you talk about environmental sustainability and governance, under governance, your privacy compliance, your privacy scores, your any fines that you have had, any data subject rights complaint that you have had, any other breaches that you have had, are part of those matrices that are assessed to measure ESG compliance. Now, last but not the least, you as an organization, are able to stand in the forefront of the customer journey. You know what data you have. You are aware that where your critical data lies, how much it is, where all it is stored, what controls are in place. So it reflects the in-depth view of an organization in terms of data, the information capture, and the information flow, cybersecurity aspect, etc. So these are the key benefits that an organization, definitely can get when they are, kind of compliant with it. These are the direct benefit. Now, you investor value, shareholder return with your brand value increase, all these are your other ROI that come into picture when you meet these compliances.
Okay, to sum up what you just said, it's zero fine and opportunity to avoid those fines and sanctions from supervisory authority, improves cybersecurity, customer loyalty and brand awareness, and improvements in the governance field, because data privacy, it's about processes in the organizations, and being aware of your information assets, because you are basically listing all information systems in some kind of register, and then you are able to use them more efficiently, right? Okay, let's discuss, along with those benefits for compliance, what are the companies that would harvest those benefits? Which sectors does the UAE data privacy law applies to? For instance, you are as DPO of one of the leading banks in the UAE, in the area. Does the law applies to you?
So that's a very interesting question, and I think we are expecting the executive directives that are supposed to come somewhere early January, as what last I heard. But in terms of applicability, the UAE federal law is pretty much in line with GDPR and the data privacy law of Saudi. Now, both of these regulation, data privacy law of Kingdom of Saudi Arabia as well as GDPR, they have extraterritorial impact. Whereas, in the case of UAE federal law, we have a mention of inside UAE. Okay, so now that inside UAE is the word where some clarity is expected, but to summarize the applicability, it is applicable for any organization, any controller, any processor that operates inside the UAE, or that targets the customer of who are residing inside the United Arab Emirates. Now, if the organization that is outside of UAE but targeting UAE resident is also or will also come under the scope of this regulation. Now, when this regulation will come into picture or will come into force, there is a requirement of setup of UAE data office. UAE data office will be in the authority or will be in power to exempt certain companies or set of organization where they feel that they don't process high volume of personal data or high volume of sensitive personal information, or they don't use technologies like AI, ML, or they don't do monitoring sort of activity. Pretty similar like GDPR. Now, this law applies to all sector, all industries, apart from government companies or government organizations which are under government control, judicial system of the country, plus any organization like banks who have their regulator and they have a similar protection regulation released. So like for banks, there is a consumer protection regulation, then federal law directly might not apply. For healthcare sector, there is a healthcare law. It's again a 29 law that was passed in 2019. So in that sector also, since there is already a law in place, hence this law will not directly apply to those companies. Now, while we we are discussing the scope, applicability, and exclusion. There is definitely, views in the market that says that even as a bank or as an healthcare provider or as any other entity, I would have been taking my trade license. I would be, kind of authorized by Department of Economy, of Dubai. So in that case, this law will have certain aspects that will be applicable to the
Mhm.
organization. The regulation that are there as of now, especially in banking sector, they doesn't talk about employee data.
Mhm.
So what does this mean? That UAE federal law will cover the employee related obligation like GDPR, because
Yeah.
it covers employee related obligation. So these are the questions which we might get more clarity as we kind of, progress ahead in the journey. But nonetheless, if you do business, if you are offering goods and services, if you are targeting UAE, resident, then definitely this laws applies to you from a business standpoint. There are other factors that will come into picture, but yeah, those will be exclusion, but that might not completely exclude you from the applicability of regulation.
Yeah, and even if you are excluded from the scope of the data protection laws, in the most cases, you would be probably regulated by some other more specialized and more strict regulation and legislation, as it happens with free zones entities. For instance, there are like two major free zones in the UAE, which is Dubai International Financial Center and Abu Dhabi Global Market. And in those two, we have specific data protection requirements that allow companies to be excluded from the federal law, but they would have to follow even more strict, more comprehensive data protection requirements, like in those two
Absolutely.
areas.
Absolutely. And if you look at DIFC law or the ADGM law, they are pretty much similar to each other, and they are kind of, again, taking cues from the golden standard of GDPR.
Yeah, absolutely. They have like similar legal basis for the processing. They have legitimate interest as a legal ground for using personal data. So indeed, those, and GDPR is much more stricter than federal law. We have a lot of exemptions in federal law that would probably make business easier in the UAE, but there are no such exemptions in those two free zones. And for instance, our company, Data Privacy Group, is registered in Maidan free zone. So, and we checked at the website of the Maidan free zone, there is no privacy regulation. And since we don't have this law in our free zone, we would be subject to the UAE federal law too. So in spite of us being as a company registered in a free zone, we would still have to follow those rules and regulations. And the final point of our webinar agenda, what companies should do to become compliant and what are the first steps of becoming compliant. I made a short list of the major points, major actions that you would need to carry out inside of your organization or group of companies. And like always, it starts with knowing your data, learning about your data. So we have to list all purposes for processing, all information systems to carry out the exercise known as ROPA, Register of Processing Activities. We would need to minimize data collection, limits its storage. We have to establish schedules for data deletion according to Article 5 of the law. We would need to implement strict security and privacy by design controls to all of our processes, which is quite hard, I must say, especially since there is no culture in the modern organization of data deletion, because data is considered to be an asset. And with the GDPR and other privacy laws, a new approach is coming into force when we treat data as a risk. So there are completely different strategies with regard to assets and risk. You try to collect, you try to keep longer all your assets, and you certainly have to avoid risk. So what federal law and other laws in the area would require companies to do is actually to establish the practices of avoiding those risks, of making the data sets smaller and keeping only useful information, useful for the purposes. Documenting data transfers outside the UAE, and appointing or outsourcing data protection officers' role. building processes to respond to data subject rights requests. Do you have privacy notice? Is there any mean of communication data subjects could contact you? Would your support people understand that they really, what they ask is really a data subject access request, and you have to follow federal law in answering these requests and meeting the requirements that might be there to answer those requests? And finally, assessing the risks for data subjects and describing all activities that you have in privacy notice to make the processing transparent. Of course, the list is huge, right? But who gonna do this? Whether the question usually asked whether certain outside consultants, some kind of outsourcers could do it for you. And as a rule, since those activities involve changes inside the processes and knowing all the processes, non-outsider could do this instead of you. It's only possible that you invite consultants to help you with, assist you with carrying out those activities. So the major precondition for succeeding in data privacy program would be training your staff, making sure that your staff is aware what personal data is when they fill the data register, making sure what are the criteria for defining the period of keeping the data when they do the deletion schedules, making sure that your data protection officer has sufficient competencies to explain to business owners and process owners what kind of activities are allowed or which are not. And the second precondition, I would say, would be allocating resources, because privacy involves a lot of heavy lifting, a lot of activities that would require not only time of your employees, but also financial resources, like getting some help from consultants or implementing some information systems that keeping track of all your data and helping you to answer subject access requests, those data subject rights. And finally, assigning responsibilities, because there are going to be no single owner of all data privacy program in your company. It would be divided into certain areas, and almost all departments would have their piece of work with regard to data privacy. Of course, making the internal organization, internal system of governing and managing these data privacy activities would really help, and assigning the initial responsibilities among the departments would definitely allow this program and this project launch. Manish, would you add something to this list?
I think the list is very exhaustive. From my experience, I just wanted to bring out the challenges that you face when you try to implement such programs and the complexities around. So the data subject request, which looks like a fairly simple obligation, actually when you try to implement it, you will not be able to do it without proper SOPs, process flows that are defined, proper templates if they are not in place, and the tools and solutions that should be in place to enable you the amount of data that you needed to respond. Same way, breach identification, data breach evaluation, risk matrix, communicating to regulatory bodies could be very tricky because the obligations are time bound. And depending upon the nature and type of breach, you might have to inform your customers also. So understand that for God forbid a breach occurs, and within X number of hours, you have to respond to regulatory bodies. And whenever you interact with regulatory bodies, you can't just say anything to them. There has to be a plan in place, a set of more activities in motion, then you can go back and tell them. Secondly, if you have to communicate to data subject, then very simple requirements like what message should be going, who should communicate, how do you identify which all customer need to be communicated, what is the best way of sending those communication emails, all that needs to be very carefully evaluated. Plus, if you are tooling it accordingly, then you have to enable the required and have the required understanding of your infrastructure, that what tools and solution will be suitable for you. You need to have right set of stakeholders engaged who understand privacy, who understand what is the requirement of this regulation, who understand what is expected out of them. Then only your initial activity of identifying personal data, identifying processes where personal data is being processed, and creating those data maps, data flow diagrams, ROPA record of processing activity documents will be, will fetch a good and a fruitful result. Plus requirements around data protection impact assessment, concept like privacy by design, how that will fit into your application environment, how it will fit in your vendor requirement, etc., will need to be considered. So these are the impact that are limited to you. Now your privacy framework will also extend to your processors, who are your service providers. They also will have certain obligation to fulfill, so that you can fulfill your obligation on time. Your third party risk management framework need to be enhanced. Your contractual clauses with the vendors need to be reviewed and obligations need to be defined. Your cross-border data movement, if any you are doing with any vendor, or your data centers are there, or you are hosting any SaaS environment, cloud-based environment, tools, solution, application, then their structure, setup, ownership, etc., everything needs to be looked into, so that you can ensure that, or you can say with a comfort that yes, I have done to a certain percent the requirements of the regulations are covered. So these are the few pointers that I wanted to highlight, where your staff member will become the key, and their understanding of privacy will become the key when you are starting this journey.
Yeah, when we speak about understanding of privacy, so we need to train our data privacy team inside the companies that would carry out those activities, that would understand all those intricacies, not limited to what just Manish said, but there is a large scope of problems and issues that might arise while implementing data privacy. And I would like to invite you to the data privacy professional course that is focused on the UAE regulations that we as Data Privacy Group and NADA Global offering in the UAE. It will start on the 10th of October. So next time we would be delivering the course, which is known as Data Privacy Professional Course. You could access the program of the course on the website of nadatraining.com. It's a first part of our data protection officer course, which is actually positions that a lot of companies would have to implement in their organizations to have like an owner, person responsible for data protection in their business. So it's both obligation, but also a great opportunity for companies to start early and to make the compliance with UAE personal data protection law work for them as a benefit, as a market differentiator that would allow improve their brand, improve the efficiency inside the company, improve information security. And I think the first step would be signing up for the course and making sure that inside the company there is like a reference point. There is a certain person that you trust, that knows all your processes that you have inside the company, and that possesses all the knowledge, all the fundamental knowledge about data privacy, and would be able to do the most of the work with regard to protecting personal data. And on the level of the whole company, of the all employees of the companies, it's highly advisable to train them through the basic initial training that would cover topics like what is personal data, what are the obligations, how our company is risking when we break certain rules of the laws, and what are the first actions that I should take, I as employee should take when I get the request from an individual to delete his or her data or to get a copy of it. So those questions would be covered in more basic course, which would take like 3 hours. But when speaking about the data privacy professional level, it would take 3 full days for the course participants to learn the topics starting from the scope of the law and information security requirements, and the position and role of DPO, the scope of the responsibilities, and risk assessments, and things like definition of the roles and the requirements that we have to include into our contracts with our data processors, with our vendors. This is a comprehensive course that is built on the basis of the guidelines and best practices from European Union on the basis of the GDPR. I deliver this course, similar course on the GDPR. I've been delivering this course 4 years, I believe, since 2017. So it makes 5 years, and I'm using the best of the charts, the best of the guidelines, best of the materials from the GDPR course to explain certain things that are present in the UAE law, but there is no coverage by the supervisory authority. There is no guidance and regulations issued so far. It would be a real advantage for participants to study this course, because they would not only know the plain requirements, the requirements of the law, but also would understand what possibly be the ways how to carry out those activities based on the multi-decade experience from the European Union. So let me show you materials. Those materials are covering the topics, the general topics of privacy, of the notion of personal data, of the legislation and its scope, of the roles, and understanding the responsibilities of your company according to the national law, the topics of risk assessments and legal basis and data protection principles. We would also cover the scope of the rights of the data subjects. What are the situations where we have to reply to delete the data, when we are exempted from this requirement. And the course covers not only UAE federal law, but also DIFC law and the ADGM data protection regulations. So we included 3 jurisdictions in the course to make sure that those of you who would change the positions and would go from one company to another doing data privacy work would be able to cope, to handle those tasks, even if you change the jurisdictions inside the UAE. Thank you everyone for coming. I hope this webinar was helpful, and looking forward to seeing you at one of the courses, or maybe during the projects when we work as consultants and helping you to comply with the federal law.